afternoon, everybody. This is Lateral Market Trends in Negotiating a Lateral Move, episode 3 of our 3-part series by Financial Poise. And the topic today, critical issues in negotiating a lateral move. You can read more about Financial Poise on slide 33 of this presentation. I'd like you to introduce our panel today. First, Dan Binstock of Garrison. Second, Jennifer Gilman of Gilman Strategic Group. Third, Amy McCormick of McCormick Schreiber. And last but certainly not least, Gary Miles of Miles Partner Placement. And everyone who is listening today is in for a real treat. We have experienced recruiters crossing the nation and representing all of the geographic areas from East Coast to the middle of the country, the good old breadbasket, all the way to the West Coast. So everyone's in for a treat today. My name's Tina Solis. I'm a partner, commercial litigator, and part of my practice at Nixon Peabody is ethics counseling. You can see all of our names on slide 5 of this presentation, and you can read our individual bios on slides 26 to 30. But neither Financial Poise nor any of us intend for this presentation to be an infomercial at all. So you don't need to listen to me read our bios, look at them at the end of the presentation if you want more information. Now, as we move through the slides today, I will direct your attention, but I don't mean to suggest that we're going to go in chronological order or that we'll necessarily hit every slide. So don't worry if you're just wind up listening to this, because the import is not in the slide presentation, but it's in the talk and discussion amongst the panelists today. That's where the meat of this presentation is. Before we get started, I'd like to remind everybody that Financial Poise webinars are supported in part by our sponsors. The sponsors for this webinar are Mood, the nation's premier online retail cannabis dispensary. And for more information on Mood, please turn to slide 2. Also, Sunburst Digital, maker of Type to Learn, the #1 typing app for children K through 12. Also, Max Asset is a sponsor. If you need to conduct an online auction, Max Asset is your turnkey solution. You can read more about Sunburst and Max Access at slide 4. The last thing before we begin and get into the content of the presentation is I must talk about, for lawyers, the disclaimer. You are not our clients and we are not your lawyers. What we do here today is merely for general educational purposes. If you have a specific scenario that you need legal advice on, we would encourage you to reach out to an attorney and get such advice. So, without further ado, let's get started with today's topic and negotiating the offer. So for those of you who may not have been able to join us for episodes 1 and 2, let me set the table a little bit. In episode 1, we talked about all of the do's and don'ts in connection with a possible lateral move. Then in episode 2, we talked about looking at the provisions in a lateral candidates partnership agreement and other things in the marketplace that may impact the timing of that move once you've done the interviews and you're getting ready to get an offer. Now, in our hypothetical scenario, we have a candidate who has gone through the interview process. He or she is now receiving offers and hopefully multiple offers. And this episode focuses on what items should be negotiated as part of that offer and how best to effectively negotiate for the candidate's benefit. So, to the content, the offer letter. What should it contain? When it arrives, what should it look like? You'll see here on slide number 10, some of the key things that I look for when a client of mine shows me an offer letter. I think some of the big ones are going to be very obvious. Salary. base compensation, bonus, what positions being offered? Are they offering a leadership role at the new firm? If you're coming in as an equity partner, what's the capital contribution, the amount of that contribution, and the timing so it's funded? Also, benefit information. That's something that I think a lot of candidates sometimes forget to ask about. Very important to take a look at. And then here you see at the bottom, other details. I think offer letters vary greatly. And so the first question that I would like to pose to our panelists is, besides what's up on slide number 10, are there anything else that you think is critical to an offer letter? And maybe it depends on the particular candidate, but are there any big ones in your mind that we're missing here? Okay, Dan and Jennifer, who wants to go first?
Jennifer, you go first.
Sure. So a lot of times when I'm working with a partner, one of the things they want to do is be at a different firm that supports their marketing and business development efforts more. And they have some really good ideas about what they want to do, but it's outside of the customary budget for each partner at their old firm. And that's one of the reasons they're moving, or there's something about the old firm that is unsupportive of that. So we like to put together, well, what is it that you want to do and how much is it going to cost, and negotiate that budget, or, the round numbers of it. And sometimes the partners I work with are moving because they need more people support. So they might want to put in there that they get to bring someone or have someone who reports to them, whether it's at the associate level or paralegal or an assistant or something like that, if it's really important to them and that's going to make it a better opportunity or make it an opportunity they would say no to.
Yeah,
I was going to say, Jennifer, I agree 100%. I think the marketing aspects and, as usual, Jennifer is always 2 steps ahead. We're gonna talk about this a little bit, but I think marketing is critical because oftentimes if there's an event or events, I mean, I see candidates all the time that have multiple events that they're used to sponsoring. And that's something that I think you want to make sure you're on the same page with the new firm about, because oftentimes those are expenses that, those could be $25,000, $50,000 depending on what the sponsorship requirements are. And if that's something that's very important to the candidate, I think it's great that you get it out there right away. So I know Mr. Binstock is waiting patiently. Dan, what other thoughts?
You mentioned salary and bonus, and title, but I think an important part is the guarantee. And how long is the compensation guaranteed? How much of it, is going to be paid as, a fixed, even if they're coming in as equity, there may be a guarantee for a period of amount. How's that going to be paid? So it's not just the amount, but how is it going to be paid? In what form or fashion? When are they going to slide into the equity system? If they're sliding into the equity system at the outset, is there a minimum, such as you will make a minimum of at least X million, no less than that, but you can make more than that? So really flushing out, what does the salary mean, and how long is it for, and what are the nuances of how that's going to be paid?
I think that's a great additional item, and we're going to talk a little bit more about guarantees a little bit later on in the presentation. But Gary's got his hand raised.
One and kind of piggybacking on that, one thing I constantly get as a request from partners, or partners ask me to request of the firm when we're at this stage, is a distribution schedule and understanding, like what percentage is distribution, what percentage is bonus, and because a lot of times, particularly in a competitive situation where there's multiple offers, a decision can come down to what the attorney's tax advisor tells them in terms of what the real dollars look like in any given situation, and what monthly cash flow is depending on their own circumstance, what they're used to. And so there's a lot of I would say added layers of that whole salary bonus discussion where partners are, I think, should ask for, and firms usually will provide that type of information. And firms that recruit a lot, have whole, they will send that along a lot of times with an offer letter.
So Gary, I think you raised an excellent point, and there are a lot of firms, candidates should not assume that distributions are monthly.
That's right.
Because that is not always the case.
Right.
And sometimes at the beginning of the year, we all know some firms, you might not get a distribution for a few months. I mean, you
Right.
probably are having the true up from the prior year, and that's a big payment. But you're absolutely right. I think cash flow can be a very
Right.
big issue. And some firms doing it on a sliding scale. You start out getting X percentage the first quarter, and does it increase every month? Does it increase quarterly? So I think that raises an excellent point, and so very important to the equation.
Right.
And I'm going to go Jennifer and then Amy.
And just piggybacking on what was said, the one thing I would add is sometimes the offer letter describes what is going to happen during the guarantee period, but the candidate isn't quite up on what's going to happen when they're thrown into the regular compensation system. So maybe you're getting distributions once a month or once a quarter during your guarantee period, but for the firm, they do it in the 15th month. Or maybe, you're being subject to certain bonuses or something else, but I would like the candidate to know what's going to happen after that, because we're hoping that they're going to stay at the firm for a long time. So it is really important to understand what your compensation is going to be when this offer letter the guarantee period is finished.
Very good point. And I know Amy wanted to raise an issue too. No?
Yeah, just a couple of things. I do think the devil is in the details a little bit, and I've never seen a perfect offer letter that describes everything completely. But I do think having some understanding of, sometimes you read something on its face and it looks great, and that might be because you're defining, let's say there's a bonus that's graduated based on collections or originations, like understanding what that means, how it's going to be calculated, and how long that calculation lasts, whether it's over the course of 15 months or 12 months or whatever that may be. So I think digging in a little bit, I wish each firm would give a set of definitions before they ever started the process, but they won't, or they don't. A couple of other things that are just perhaps silly, but not necessarily. If there's an anticipated start date, usually all of that can be negotiated. Duration of the offer. Does it have an end date? And that's important to know. For some firms, billable hours, actual hours billed are important to the offer. And if so, that would be nice to have that detail in as well.
So I think you raise a lot of very key and critical issues. I mean, I know people get further on in their career and they have books of business and they say, oh, well, why do I need to know what the billable hours is going to be? I work hard and I'm bringing a big book, but for some of these new firms, and I think especially today where law firms are more competitive than ever, there are different sets of expectations that some firms have in terms of billable hours. And if that's important to the new firm, it needs to be in there so the candidate and the firm is on the same page. Gary's got his hand raised.
And right in line with that, same thing about expectations on billing rates and how much you're going to raise them. The other thing that I think is really important, and it's not always in the offer, but it definitely needs to be asked about, because you'll see the terminology that like Amy was talking about. You'll see terminology of different things like, some firms will call, responsible matter credit, originating credit, or client relationship, whatever their titles are. And I think it's really important that the attorney make sure that they come back after receiving that and get clear definitions on those things. And I would even advise the best way to do that is not only get their definition, but then pose real-time scenarios where, for example, if you represent a client that the firm also represents, and throughout the process, you've been talking about the synergy of this client and trying to expand the wallet share, what happens when you actually do? Do you actually get the key credit, or is, how do the different buckets work, et cetera? Because there can be a lot of like really finite and fine differentiation that can greatly impact how that offer turns into the execution of compensation and reward based on the terminology that's being used and how the firms address those issues, like splitting of credit, sharing of credit, or is there one partner that has these, the client relationship locked in, and then how does your additional revenue fall into that? There's just a lot of gray area that is best defined and asked about at this point in the process.
I think that's absolutely right. I mean, I had a situation once where client was joining firm, and it just so happened that one of my client's clients was also a client of the firm that she was joining. And I said, wait a minute, we have to figure out origination credit. We were in the offer stage, and I said, we have to figure out origination credit here. And she said, do you think so? And I said, absolutely, because you've got a partner that's already at this firm that is, in charge of that relationship, and you're coming in. How are we going to divvy that up? And so the firm, thankfully, was open to having a discussion, and we worked that out at the offer stage. And I'm thrilled that we did, because it turns out she joined, and the fair way we wound up doing it is anything that the other partner generated, that person got credit for. Anything that she brought in or generated, she got credit for. And her business took off with that particular client. And the type of work that the other partner was doing, it sort of stagnated and dropped off. And, it's now however many years later, and we still, she's like, boy, that was the best thing we ever did. So I want to move on, but I think the important takeaway for the audience to understand here is there's no finite list of what the offer letter should contain. It needs to be tailored to the specific candidate and his or her specific needs. And I think for the audience, you've heard from, our very well-respected panelists here who have a deep, deep base of knowledge that the offer letter can mean a lot of different things to a lot of different people. It really depends on what's important to the candidate. So I want to, right here, it should contain all the must-haves, but it should also be tailored to the specific candidate's needs. So I want to just touch on this issue before we really delve into some of the pieces that you all have been mentioning. Ever any situations, and I'm really curious to hear this, and it's part of the reason that I want to ask the question. Are there any situations where you don't recommend negotiating an offer? Gary's nodding his head. What are those?
90% of the time, maybe 95% of the time, it's all negotiable. There are times when I've been in situations where firms have come out with their best home run offer in a competitive situation, and there's not much room to negotiate, and we as the professional who has dealt with that firm understands that maybe this firm is stretching to the limits of where they can go, and to negotiate back is something that might just take the offer off the table. They might just say, we can't compete. This is, and so I think you have to be, it's not usually the case, but you have to be cognizant of that, and dealing with a recruiting professional that has the experience and the EQ and the knowledge of the firms in depth that you're dealing with to let you know when is not a good time to negotiate back. Because I've seen people blow really good situations because they negotiated back when they shouldn't have, or negotiated over something that didn't really need to be negotiated. You know what I mean? And sent a different message about how they might fit culturally, and which can create a deal at any point in time.
Yeah, I really agree that partners need to think about everything you ask is saying so much about you, about what your values are, what your judgment is, how you prioritize what's important and what's not important, how good your business judgment is. Exactly what you're saying, Gary, about the culture. And I think I do not agree with Sheryl Sandberg's book Lean In, which just says you always have to negotiate, because if you don't negotiate, you're leaving something on the table. My approach to that is you should always negotiate if there's a reason to negotiate, if there's a justification for the negotiation, and if you can explain why you're negotiating, not just negotiating because you feel like you need to negotiate. So sometimes if someone's getting a comp increase of several $100,000, um, they and they're not leaving anything on the table, negotiating just is a red flag. They're just trying to, this person's. So I think I don't recommend always negotiating an offer unless there's really a reason to negotiate, such as, and oftentimes the negotiation is with the firm you're leaving because they're going to counter and try to keep you and things like that. So I really agree with what you brought up there, Gary, and it's such an important point.
Jennifer, I know you had your
Yeah.
hand raised. You want
So
to
I
add
agree
something?
with both of them, but I would say also that, yeah, it sends a message if you're getting a raise of several $100,000 and then you're negotiating over something that seems like nickel and diming the firm. Like, oh, this was better at my old firm and I need this particular resource, or this, I need a different health insurance number, or whatever it is. But if you do decide there are some things that are truly important to you and you believe they're worth negotiating and you think that they're not going to paint you in a bad light, you should probably be ready to accept the offer when the firm says yes to all of the things that you've made them jump through hoops to get done for you, because that leaves a bad taste in a firm's mouth when they go to a lot of trouble and then you say, oh, I was just thinking about it.
Gary's raising his hand. Go right ahead.
I absolutely agree with Jennifer. I think there's two key points that are implicit in what she said that should also be taken away from this discussion. So, and sometimes this happens when you're just looking at one firm. Sometimes this happens when you're looking at multiple firms. One, if you're going to negotiate, be prepared to accept. So you really should only be negotiating with the firm where you think it's the best fit in a competitive landscape. And oftentimes, even though a lot of partners come into the process thinking, you're my agent, the recruiter is my agent, and I want you negotiating my terms because I don't want, they have this kind of, I don't know if you'd call it an old line model, or, the where I don't want to negotiate with my partners, my future partners, about comp. But in terms of being most effective, and at the same time not sending some of those bad messages that you might not even be intending to send, when you really get down to those fine point negotiations, it really should happen most times between the partner and the decision maker, or whoever's leading the charge at the firm that you're thinking about going to. Over my 20-year experience, well, almost 20-year experience, placing hundreds of partners, it almost, I won't say it's never failed, but it's really impactful when, if there are points that need to be negotiated, the partner's like, look, this is this is what I really need to feel comfortable and all in. And if that can be done, then I'm in. I can sign. I'll sign on today. Maybe I can't start today, but that because on the firm side, that's a level of engagement where they're like, okay, this individual is an adult. They're going to interact within the partnership like a partner. Though there's so many benefits that come out from that. So I do think Jennifer made a really important point, and I just wanted to kind of delve into some of the implicit elements of what she was, I think, also saying.
I appreciate everybody's comments here because I think they're all very important and great takeaways for the audience. I want to raise one more question, and then we are going to delve into these component pieces. And it happens to be the second question on this slide, 13. Are there any terms or conditions that you've seen in an offer letter and you sort of go, oh boy, this gives me some pause, this gives me some concern here? I'm again, my red flag slide, I'm very curious to your answers to these two questions. So anyone want to tackle that one first?
I don't like quick deadlines unless there's a reason. If a firm's got to fill a search and they've got someone on hold, you're their first choice and they don't want to lose number two, then it makes sense. And then they should explain, here's why we're putting a short, end date on here. But otherwise, a date that is, they send it out on Thursday and say we'd like an answer by Monday. It seems unnecessarily, it's not like an associate search where they have a job to fill. It's a business deal. It's a merger. And rushing something like that, I think, shows desperation and not respectful of the partners' need to fully make the decision. If they're worried about shopping the offer or counter offers, deal with that another way. But I don't know. I don't like an end date that's too soon without a good justification.
Sure, Gary.
And Tina, I know I'm going to get a big high five from you on this, but the one thing that always sticks out is the guarantee that's not really a guarantee. And there's 1,000 different ways for that to happen, and firms are all doing it. Not all, but there's a lot of firms that are doing it now, and you have to figure out like just how soft is the soft language that and sometimes it even gets down to maybe you have to read the partnership manual as opposed to just their partnership agreement, because it could be hidden on page 58 or something like that. But it gives me big red flags when firms say, well, we guarantee this, but here's an expectation, and it's not clearly explained that, oh, that's to set comp, potentially set comp after the guarantee, or when there's ambiguity there, that can be a problem.
I agree. And for the record, I did not pay Gary to say that in any way, shape, or form, but he's speaking my language by bringing that up. So thank you, Gary.
Yeah.
I also
Jennifer,
think it's a red flag if they won't include a term that you have negotiated. And they try and say, oh, no, we don't need to put that in the offer letter. Well, that is a really important thing to this particular partner. And if it's not in the offer, it's going to make this partner uncomfortable.
And I do think, and Gary and I were talking about this sort of before we jumped on this call. I think trust in the process is very important between the candidate and the firm. And to Jennifer's point, if you've negotiated a term and then you get the offer letter and it's not there, that doesn't necessarily sit well, because the candidate feels like, well, am I not being listened to, or do you not really value me? And so I think that's a great point. Okay, I now want to move on. This is a great conversation. We could go for 2 hours, I think, on this. But now I want to get down into the nitty gritty here, because I'm very interested. Negotiating compensation. This is the big one, and we've already touched on it a little bit, but a couple of points that I want to focus on. What's the best approach in terms of going back to the firm? How how do you make the ask, and who should make the ask? So who wants to jump in and tackle that one? Because I know you all have plenty of experience by guiding hundreds and hundreds of folks through this process. So what do you think?
It depends.
That's fair. And on what, Amy? On what?
Well, usually at that stage of the game at the partner level, it is the partner having, at least in my experience, the partners having direct conversations with the firm, and not without our coaching very often in how to how to make the ask. And usually as I think has already been mentioned today, it is really important very often to explain the rationale, for what you want to negotiate, or questions that you need answered before you negotiate a particular issue. But and I do have candidates who have asked me to actually have those initial conversations with the client. I'm usually happy to do that, but it really does depend. It depends on how the process has gone with the candidate, relationships, lots of different things. And sometimes we can be, even if we're not making the formal ask, we can be a little bit of a precursor and an information provider and a coach on both sides.
Gary, go ahead.
Yeah, Amy just kind of really got into it at the end. I find that this question is often dictated by the nature of what I'm dealing with, right? Like, now, in most cases, I try whenever possible to really kind of at least socialize what a general range of compensation that might take to get somebody to join a firm on the front end of the process. Because I'm really big on not wasting time and going all the way down the road and then people being really disappointed at the end of the day. It's not that we're talking comp per se at the very beginning of the process, but my practice is such that I'm not really doing a lot of quote unquote partner searches where a firm is like, we have this need and we need someone who does this. And mine is much more oriented towards strategic visions of what firms are trying to accomplish, and then bringing them talent that the talent may not necessarily be looking to move, needing to move, but when presented with a really compelling opportunity, they fall in love with the possibility of being compelled to leave on the compensation side of things, right? And so it can really, really depend on what I'm dealing with, but I like to get that stuff out front. And the bigger the deal is, the more complex it is, the you want to get, and a lot of times this happens, right? When you do multiple partner deals, a lot of times some of those asks are right up front. And whether it's comp, whether it's make wholes, all of that stuff can be a part of those transactions and be almost like, with a firm, can you play in this ballpark, right? Can you swim in this ocean? When it comes down to negotiating some of those, because as those processes move forward, what's often stated at the front end, particularly in a competitive environment, changes. Then it really needs to be the partner or the shepherd of a group of partners making the ask and having built through the process the relationship with the decision makers that can impact that ask. Because at the end of the day, there is something that still exists in our business, despite the wonderful efforts of folks like that are on this panel, like Dan and Amy and Jennifer, to educate law firms about that recruiters aren't just out there digging in their pockets. If we're making the asks, sometimes at the end game, when they're doing their pro forma, like, is the recruiter just trying to enhance their fee, right? How much of that is coming from us and coaching the people to ask for that versus where they feel it's genuine coming directly from the partners.
I think, Gary, that's spot on. And I think when you get to that point in time, it's very important, again, from a trust building standpoint,
Right.
it's important for that partner, or to use your terminology, the shepherd of the group, if there's multiple partners, to sit down and make that ask with management, because that's part of the trust building. Listen, you told me what you can do and provide this platform for me, and I'm coming back to you and saying, this is what it takes to make it work. And I think that's right. Here's something that I hear all the time, and curious to all of your thoughts: multiple offers in terms of using them for leverage. What are your thoughts on that? I hear Gary's doing this. He's not quite sure. What are your thoughts on that? Because I'm sure you get those same questions just like I do. Jennifer's raising her hand.
Well, if it comes down to, and the candidate or group has, like, say, 3 offers, and the firm that they feel is really the best fit is not the highest amount, we may try to negotiate a little bit by explaining, hey, they'd really like to come to your firm, but that's a lot of money to leave on the table. This other offer is a little bit higher. Is there anything you can do? Is there anywhere we can go with that? But just like we said with the other negotiation, you have to be prepared to say yes when the firm comes back with something. You can't just be negotiating for sport to see how far you can drive up the offer. I would tell them that they need to know which is the firm they would like to choose and try to figure out what is the best that firm can do.
I agree with that. I think it's very important that you pick the horse that you want to win the race, and don't start negotiating unless you're prepared to say yes, because otherwise leave a very bad taste in the firm's mouth. Gary, go ahead.
And part of this comes back to something we were talking about earlier, the real diligence in understanding what the offer actually says. Like, it's really important when you get multiple offers where base compensation may differ, understanding like what a firm's like the diligence that firms do on partners with the whole LPQs, and God knows, like, there are firms, we're not going to name it, but there are firms with 50 and 60 page LPQs that they make partners fill out, right? And the partner should do the same diligence on the firm. Like, you should know after going through a process, what's the 5-year run rate on overrun as it, with respect to budget. Does that turn into an overrun for partners? Are you looking at a partnership versus a corporation where the money might be different, but there's the state tax implications could be very, like, there are a lot of details. I say the devil's in the details, where you really need someone, you really need yourself, but also someone like a Tina, and hopefully both, someone like Tina and a recruiter that understands all the complexities to get you to see which is what offers really mean in terms of real dollars. And then I absolutely agree with Jennifer. It's got to be, you decide what firm, and then be prepared to commit once you make the ask. And it should come from the partner or partner to chairman, or whatever. But I think that's very critical, understanding how all those offers really pan out, in terms of the real dollars. What does it mean to have the equity? Like, is a firm beating budget by 5%, or are they average beating budget by 40%? Like,
had that very conversation earlier this week.
Yeah.
Well, they're this far ahead of budget. Well, what does that mean? Because did they have the same budget this year that they had last year?
Yeah, right.
Or is their budget for this year up 20%, and then it's, X percentage over that 20%. So
right.
I think that is exactly right. And so let me pose a related question. How best to ask for that information? Because I know sometimes I say to clients, well, wait a minute. Have you asked about that? Have you looked at the financials? And they're always like, oh, I'm scared to ask that, Tina. So what's your advice in terms of how to ask for it and when in the process? Do you wait till you get the offer? Because I could see a lot, I mean, I sign a lot of NDAs for my clients when I'm looking at certain documents from the firm. So Gary, go ahead.
So I think this is one, and I'd love to hear the other panelists. I think this is one where the recruiter should make the ask, because especially when you're talking, and this plays out most intensely or impactfully in a multi-firm, you know, in a multiple firm offer landscape, right? Where the partners decide. I think there are ways for a recruiter to ask the firm for that information in a way that where the firm will almost be more willing to do it and want to do it, because it's almost like you're coaching, like, look, this is how this might help you win here. It's important that this potentially could be an advantage for you without getting into all the details of the offers. This is an advantage that you have, and I think it'd be really in your best interest to take them behind the curtain and show them 5 years of performance. Show them where, like, if the firm's in a point system, a band system, whatever system they use, where do peers, in terms of what they are expected to do, show them what those comp charts look like for the last 5 years, redacted, so they have a better sense of where they might fit in after their guarantee comes down. Is their guarantee in line, or is it way outside the, are they going to have a target on their back because they're way above? There's a lot of information that can be really impactful in a candidate's decision that firms, and it might be, hey, you have to come into the office to look at it. It might, some firms will send it out confidentially, but there's a lot that a recruiter can help the firm put its best foot forward. And as a recruiter, when I'm in these competitive landscape situations, I try to give every firm when they have to put their best foot forward, what they need to do. So if there's information like that, I think that request should come from the recruiter, because we might know the additional information along in consultation with someone like yourself, Tina, an expert. Together, putting our heads together, we might know they might want the question of what's the overrun, and then there might be what's question B, C, and D behind that data that really gives them a full picture of the difference of the firms that they're looking at, or the difference between the firms that they're looking at.
And I think, Gary, when you raise the point about you don't want to have a target on your back, I think that ties back into what we were talking about negotiating the comp.
Right.
Because there is, I mean, we all know when you move laterally, firms are competitive for laterals, right? And oftentimes they will pay a premium.
Yep.
But after that guarantee period ends, if your book is here and you're currently being comped here, that's a tough spot when that guarantee period ends. So I think, again, knowing when to negotiate and how much, and sort of picking the points that you really feel strongly about, I think that's a good takeaway. Anybody else had thoughts in addition to Gary? I don't want to leave this topic if anybody else had. Go ahead, Jennifer.
I agree with everything Gary said, but I didn't hear anybody mention negotiating the period of time that the firm looks at for the first year. There's some ramp up time coming into a new firm and transferring over clients. And, if you know that your candidate is okay with 30 days of ramp up and you ask for 90, maybe you get 60, maybe the firm will do a pro rata, maybe they'll do a 15-month first year, maybe they'll look at something else. I find that is very helpful for candidates.
So Jennifer, that's an excellent point.
Yeah.
And we had not talked about that. And I think that goes back to know what's in your offer, because if your metrics for the first 12-month period, there's the same level of expectation on the revenue generation for that first 12-month period as there is for that second 12-month period, you're likely to be at a disadvantage for that first 12 months, because it's going to take in most situations, by the time you build, you work on the matter, you get the bills reviewed, you get them out, you're in a good scenario, 60 to 90 days out before that bill arrives on the client's desk. And there's a lag in those collections. So I think that's an excellent point. And, you know, I'm starting to see a little bit more ramp up language in offers. And I don't know if that's just because they're tired of me and my red lines. So they're just like, we're going to beat you to the punch, Tina. But I think it's really important. And, you know, either you've got to make it a 15-month first year, or you've got to build that language in there and adjust the first year metrics. So thank you for sharing that, Jennifer. That's an excellent point. Okay. As always, you guys do such a great job. We always run so tight on time. Okay. I'm going to jump around here a little bit. Let's talk about billing rates and origination credit. Because I think those are important things to discuss. And Gary, you mentioned this sort of at the top of the hour in terms of making sure you're on the same page for billing rates. I would hope that it was something that was talked about in the interview process. You know, that would be my hope, right? I see a lot of people shaking their heads. But if for some reason the offer letter arrives and it's silent on that issue, how do you recommend dealing with that? Because I know from an ethics counsel standpoint and from the lawyer standpoint, I'm always insistent that billing rates are in there. But I want to hear your thoughts on the approach you take. Tell everybody to put it in there.
Oh, was that a question for Gary?
That's a question for any of you.
I think it's a very important thing. I haven't seen it change on people, but I think it's obviously important to put in the letter, but billing rates are always subject to discounts and grandfather rates. And, you know, if it's a really important deal, I feel like if you don't have that level of trust at that time, I feel like it's a sign of a bigger problem if it needs to be in the letter. That like you're insisting, I think it could almost look like they don't trust the representation. But the more important conversation is if they're going up market and they're going to have to raise their rates, is just how long is the runway going to be? The existing clients that are billed at 1,200 and you want me to be at 1,450, 1,500, how long is it going to take? And what is going to be the ramp up period so that we don't have sticker shock with my new clients when I'm telling them about where I'm going? The first thing they said, what's your rate going to be? So it's obviously an important discussion that needs to be had very early in the process. And I'm actually surprised when these discussions don't happen quite as early as they should, and oftentimes though they don't know what the billing rate is, because part of it is what's the offer going to be, and then they have to run all the numbers and say, all right, in order for us to get their offer at this number, we're going to have to raise their billing rate by this. So that's something that I'll use when I'm talking to partners to say, sure, we can try to get you that much, but you know, it's going to be hard to keep your rate. You can't have your cake and eat it too. So understanding the sliding scale element where one, you know, you're essentially robbing Peter to pay Paul in one of those situations, because the money's got to come from somewhere to keep up the profit margin relatively, consistent with where the firm needs to be. Gary?
It's something Dan said, it actually just registered. I've actually had situations over the last 5-6 years where I've, placed people where they went through, they had discussions, they thought there was going to be a certain amount of flexibility around rates, and that they would be given some time to quote unquote ramp up, but instead where they came in and the clients and the work that they were working on were able to be at rates, but like as the practice moved forward, 6 months, if they're bringing in new clients or trying to bring in new clients and they're finding out that oh, the rate we allow to bring in new clients won't go below 1,400, or like Dan said, or 1,500. And where it actually, caused issues with people that had made moves and felt like, that this was not it was not as clearly delineated, in the process. And they talked about it obviously, but it wasn't like it may not have been in an offer. And I think Jennifer made this point earlier, the ramp up time that you're going to get to. Part of that ramp up time is, how are you going to have to raise your rates? How long is it going to take? Are you going to be able to, bring in continuing work from continuing clients, or new work from continuing clients? Does that have to go in at higher rates? Like you really need to be clear on that. Cause I actually have had a couple of situations over my career where, I think it really impacted the performance, or how the performance was judged by the firm where someone went, because they had to have higher rates for certain types of work than they thought they were going to have in that first transition year. You know what I mean? So it is a very sticky thing that you need to make sure you pay attention to as a partner going into a new firm.
I think that's right. And, something else is, if you're a lateral candidate and you are giving a certain client a discounted rate for a certain type of work, I always say to lateral candidates that I represent, okay, here's the billing rate that's in the offer letter. Do we have a problem? Do you have any clients that you significantly discount? Because yes, there's usually flexibility, but let's build that in there. Because
Right.
sometimes if there's a discount, that discount is set forth in the engagement letter, and the
Right.
client has the expectation that until the next engagement letter is signed, or until your annual rates are going to be changed, that's locked in. And I like to avoid that bumpiness. So I think, yeah, and Jennifer's raising her hand. Go ahead.
Yeah, and I would say also you want to know how long the ramp up time for changing the rates is, because I've seen when candidates are moving up market, some firms will say we'll give you a couple of years to change the rates, and some firms want to see it happen in a couple of quarters, and they may feel a lot of stress about that. And when it comes to the guarantee period being over and being thrown in the pool with everybody else for compensation, that counts against you for realization rates, right? A
Right.
lot of firms will use that not to give you the comp that you're looking for, because everybody else is billing at 1,800 and you're billing this client at 1,200, and now your realization rate doesn't look good. So I think that these are conversations that you want to have, not only like, can I grandfather somebody in, but when will that rate go up? How long will that last for? Is it good on new matters for the same client? What will the next raise be, and how often will we raise it? Are we talking yearly, or are you asking me to raise rates more often until I get to the regular firm billing rate? Because some of those questions get answered differently at different firms.
Well, I think, Jennifer, you raise the realization rate is an important point that we tinkered on talking about, but let's talk about that for a minute, because I think not realization means different things to different people. So number one, you need to make sure that the candidate and the firm is on the same page with regard to what the definition of that is. And, if you got A rates, but you're giving a discount, your realization is typically set against the A rate. And not a lot of candidates understand that. So again, realization coupled with the ramp up, the discounts, everything we've been talking about, that's something that I always look for in the offer letters. And, we kind of skipped bonuses because of time, but if you've got a tiered bonus structure and you're going to get additional comp based on this tier, and then if you generate another 200,000, you get even more, you better make certain that you know how that realization is characterized, because I've had clients come to me where I didn't represent them in the move, but they come a year later because they say, well, wait a minute, I thought I was getting this bonus based on this amount of revenue. And they're telling me that not all that revenue counts because it wasn't above 95%. And I say, well, give me your letter, give me your agreement. And sure enough, it's silent. So go ahead, Gary.
So that gets back to something we talked about very early in this webinar, the language of the offer letter, because one way that firms will quote unquote soft guarantee you is to write the language in accordance with expected practice hygiene or fiscal hygiene or whatever metrics. And it'll be a very general term that you won't find in the offer letter. You won't see it in their partnership agreement, except stated the same way. It may not be until the manual where you find out, like, if you don't have an 84% realization rate, no matter what they've said, you haven't met the basic practice hygiene. If you haven't billed a certain number of hours, although it's becoming less and less about hours and more about collections on time as it relates to your financial hygiene, practice hygiene, right? And so that's where you really have to be diligent and make sure that and that's why having someone like Tina, who has done this over and over and over again and looked and seen all the tricks that firms can play in terms of protecting themselves from missing big on a lateral acquisition, because at the end of the day, that's what every firm is trying to do, trying to give themselves downside protection if a lateral doesn't perform. And so but that's, I just wanted to kind of bring that all back around, because what Jennifer's talking about, what we're talking about here is definitions mean everything. The lexicon means everything, and understanding that it might not, you may have to go 3 or 4 layers deep to figure out what that lexicon actually means and how it might impact you in year 1, year 2, after the guarantee comes down, etc. So
one of the takeaways here is that there's no way for the average lateral partner to know what they don't know. And there's so much that they don't know.
that's right.
And they can be the best attorneys, but this is like the average person trying to negotiate an underwriting process with a life insurance company. There's just so much to not know.
I think that's exactly right. And that's why I think it's important, if you're getting into the lateral process, you need to make sure that you've got good advisors. You need to have a good recruiter supporting you, and you need to have counsel, because it is a very complicated process. And we've got 2 minutes left. So I've got one more thing that I'm curious about your thoughts on. We're seeing lots of signing bonuses, lots of make whole bonuses these days. And oftentimes hand in glove with those is a promissory note. Whether it's a year forgiveness, 2-year forgiveness, 3-year, whatever it is. Curious about your thoughts on negotiating the terms of those promissory notes. Is that something that you recommend? Is it something you not recommend? What have you seen? Share your thoughts here, because like I said, we've got 2 minutes.
They can be negotiated. They can absolutely be negotiated. Or I'm saying that, you tell me if I'm wrong, but I've seen them negotiated. Whether it's changing the duration, I think that's something that I've seen.
Yeah, I think firms are erring actually now on the side of trying to elongate the terms. And it's not just in the lateral move. We're seeing many more firms utilize this for particularly big overperformance budgets. Overperformance bonuses related to their own partnership, right? And the reason they try to elongate those terms is because it works as a sort of guarantee that you're going to have the person there for a life. It's going to make it harder. It's kind of like that golden handcuffs for a period of time. And it varies widely from firm to firm on who will negotiate it. And as all things, it also varies. What's negotiable is depending on how impactful a partner or a group's practice, how potentially accretive and can it be accelerated, the firms will do amazing things. The higher up the ladder that, that kind of delta goes. The more impactful and accretive the practice is, the better chance you have to negotiate those types of things. But you're going to see pushback because firms want to lock people in and say, hey, you're going to be here. You're not going to take this 2-year guarantee, and then in year 3, if we have a down year, you're looking to go somewhere else. You know what I mean? So I think it gets back to the whole trust factor as well. I typically don't try to coach people against negotiating those terms, particularly when you're talking about things like make wholes and where, it's really added cost on a pro forma for the firm. Like, I think partners have to be sensitive to that because it does matter in today's law firm world.
And I think you don't want to give the impression that you're not planning to stay long enough to
Right.
take,
Right.
Yeah, absolutely. I think that can send a really bad message.
I think so too, although I will tell you, I think there are things on the edges. So for example, if there were a disability or death of the partner, should that promissory note, because I'm with you 100% on the message. I don't think you want to send a bad message, but I do think sometimes there's little things like that if I see it, I think, well, wait a minute. If there were a long-term disability or an unfortunate and untimely death or something, we should have language in there so the poor spouse and the children are not responsible for this. So
and that goes with the same thing, like even locking away the promise, but even just regular bonuses. Sometimes firms want to pay or make wholes. They want to pay some of it now, some of it next fiscal year, some of it at the end. Like that death or disability language is, I know I included in all my contracts with law firms, right? Like I am not refunding you if there's something beyond anybody's foresight or control, right? That ends a partner's ability to be who they were supposed to be at your law firm, right? So I think that's a good clause to have in any of those situations.
I think that's right. Okay, thank you again. It's been great. Thank you for your participation this year. Really, really appreciate it. You've been fantastic. And for the audience, I am going to open it up. I know we've run over, and so we may not have any questions right now, given that we've run over. Okay. Going once, going twice. Thank you to our panelists. Thanks for listening today. Really appreciate it, and hope to see everyone next
Thank you,
week.
Tina. Great.
Thank you, Tina. Really appreciate it.
Thanks for putting it together. This was great.
Yeah.
All right. Thanks, everyone.
Bye, everyone.
Okay.
Bye-bye.
Bye-bye.